Good afternoon, everybody. We're going to go ahead and get started. My name is Lori Craner, and I am co-director of the Collaboratory Against Hate with Kathy Blee. And we are really delighted to welcome you to our first Collaboratory Against Hate seminar of the spring semester. We have a great lineup of talks this semester. We'll have at least 4 talks. And this one I'm really excited about. We are going to hear from our colleagues right here at the University of Pittsburgh about the challenges, opportunities, and pitfalls of using civil, non-criminal legal strategies to combat white supremacist extremism, as well as the complexities of serving as academic experts in these cases. So we have 2 speakers today. First up will be Kathy Blee, who is a distinguished professor of sociology at Pitt, as well as the dean of Pitt's Dietrich School of Arts and Sciences. Most of her scholarship is based on analysis of up-close ethnographic observations and interviews with white supremacists in the United States. And she has served as an expert witness in a number of cases, including the civil suit against the organizers of the violent Unite the Right events in Charlottesville in 2017. So Kathy will speak for about 20 minutes, and then William Chip Carter will speak after that. He is a professor of law at Pitt, and he specializes in constitutional law, civil rights, race in the law, and civil litigation. And he is also a former dean of the Pitt Law School. It is a delight to have these great speakers and colleagues here to talk with us today. I know that some of you may have some questions for them. I ask that you put your questions in the chat as we go along, and I will be taking questions from the chat to pose to the speakers at the end. So with that, let's go ahead and get started.
Thank you, Laurie, and I appreciate everyone who's come today. So I want to talk a little bit about the strategy of using civil cases as a way of disabling violent white supremacism in the United States. So as you may know, there's a history of this with some success. So in 1981, in a very famous case, there was a $7 million judgment against the United Klans of America based on an action that several of their members took, where they abducted Michael Donald, who was a young African-American man who they just selected at random off the streets in Mobile, Alabama. They murdered him, hung him. That judgment collapsed that Klan. And that was one of the big cases that precipitated a variety of other actions, many of them by the Southern Poverty Law Center, including another very famous case in 2000, where the Aryan Nations was sued in a civil case, and there was a $6 million verdict against them, which caused the Aryan Nations to have to sell their 20-acre compound up in Idaho, where they had the Aryan World Congress gatherings, and it caused that organization to splinter. So there's definitely been some pretty major effects on disrupting white supremacism through this. So I want to talk about the most recent case, which Lori mentioned. This is a federal civil case that was brought against more than a dozen white supremacist leaders. So these are leaders of Ku Klux Klans, neo-Nazis, and other kinds of groups who conspired to foment racially motivated violence in the form of bringing hundreds of white supremacists to Charlottesville in August of 2017, where they first marched on Friday night across the University of Virginia campus, holding fiery torches and chanting, "Jews will not replace us, and you," meaning all who they don't consider white, "will not replace us," and surrounded UVA students standing in front of a statue of Thomas Jefferson. And then those very same white supremacists were marched into the heart of the city of Charlottesville the next day in this effort to, quote, unite the right, where they violently attacked counter protesters and bystanders. So as I think probably most people know, Heather Heyer was killed in a car assault as part of that episode, and quite a number of people were injured, some of them very seriously, in beatings and attacks by the white supremacists. A group of the injured were the plaintiffs in the case. And the idea of this case, which was a very large case involving 5 different large law firms, the idea of the case was to try to hold the leadership accountable for the violent actions that took place on in Charlottesville and on the UVA campus. Because just like organized crime bosses, leaders of white supremacist groups are very adept at using other people to commit violence. So efforts to go after people for white supremacist violence often, end up arresting people who are pretty low level and not the leadership. So this case was brought under a Reconstruction era anti-Klan conspiracy law that Chip will be talking about, I think, a little bit, and under state conspiracy law. So just to remember, this is not a criminal case, it's a civil case. The Department of Justice in 2017 under President Trump did not pursue federal criminal conspiracy charges from the actions at Charlottesville. So this is an alternative. So I worked on this case for a little over 3 years as a co-expert with Pete Simi, somebody who I've worked with a long time as a colleague from Chapman University. And we worked as an expert for the plaintiffs, prepared an expert report and testified and so forth. So what we were asked to do was apply our expertise as scholars of American white supremacism to look at the characteristics of the actions taken by the white supremacists in Charlottesville and assess whether these mapped onto the historical patterns of white supremacist movement in the United States. So what we were given is a very, very large amount of material that was gathered primarily as a result of subpoenas of the defendants. And so that included posts on Discord. Discord's an encrypted platform that is used by just regular gamers, non-political gamers, but has also become kind of a haven for white supremacists. And the Discord platform was used to organize the Unite the Right action in Charlottesville. So we were given about 500,000 Discord posts, hundreds of thousands of cell phone tech records and text messages and call logs, and just an uncountable amount of information from social media across multiple platforms, podcasts, all kinds of things, and asked to analyze this. And what we concluded in our report was that the defendants, the leaders, remember, of white supremacist groups, did use the same kind of standard practices that leaders of white supremacist movements have used for the last 150 years, since the first Klan after the Civil War. And those practices were primarily what sociologists would call front and backstage, that they made claims when there was a public audience that were diametrically opposite of claims they were making when in private. So when they knew there was an audience, they were telling people coming to the Unite the Right rally to be nonviolent. And when they were, quote, backstage, where they thought they were not being observed, they were telling the very same people the opposite. They used doublespeak. This is a very common strategy in white supremacism. They used messages that they intended to be heard differently by people in the know, by people who knew white supremacism codes and others. Claims of joking, they would say things about advocating violence and end it with, but I'm just joking. And finally, efforts to create plausible deniability, especially deniability for the leader's culpability. We also found that they were able to coordinate this because they made use of an existing white supremacist extremist culture that has existed for a long time. And it allowed, that culture meant that people who came to Charlottesville, the quote, sort of foot soldiers of the white supremacist movement, knew exactly how to interpret the memes and codes and insider comments and jokes that leaders were making. And so that allowed white supremacist leaders to coordinate action in the absence of having to give an explicit command. They never had to say, go out and commit violence. They could do it in this indirect way because the people they were talking to knew the codes. So just to give you a couple of examples, it was not uncommon for the leaders to tell their followers, just remember this is a nonviolent event. And at the end of that statement, there would be a little emoticon of a bowl cut, of a haircut, a bowl cut. And that was for people in the know, for white supremacists. That refers to Dylan Roof, who murdered 9 parishioners in the African-American church in Charlottesville, North Carolina. Dylan often sported a bowl cut. Or they used insider language like HH, which for Heil Hitler, the H being the 8th letter of the alphabet, or the 14 words to reference a phrase by the terrorist David Lane. So one of the leaders, for example, had a hashtag. The hashtag was all one word, Stop the Hate 1488. So that's a perfect example of a double speak, Stop the Hate, followed by 2 codes that indicate an advocacy of violence. Okay, so let me turn to the opportunities and drawbacks about civil actions of this sort, and prefacing this by, just remember, I'm not an attorney, but Chip is, and he will correct my misperceptions here. But from the point of view of somebody who worked on a case, not as a lawyer, here's what I see. One good thing about these kinds of civil actions is they have the possibility of really debilitating white supremacist groups, not just leaders, but groups. So obviously large judgments can bankrupt groups, cause them to give up property. They could put liens on them that follow them their whole life. They also cause infighting, and infighting to become even more public, which happened over the course of the 3.5 years it took to bring this case to trial. Secondly, they expose. So one really good thing about the use of courts, even civil courts, is it compromises the anonymity that white supremacists rely on. So they rely on the ability of people not to know them or not to know what they're doing. They become quite exposed in these cases. And it generates a great deal of information about how white supremacist movements work. The depositions, subpoenas, and so forth generate a lot of information. And lastly, in an interesting way, it provided a controlled environment for the victims of white supremacist violence to face their white supremacist attackers without, fearing additional harm. So the trial in itself provides that. But there's drawbacks, and this Charlottesville case, I think, is a really good example of the drawbacks. High-profile cases like this provide white supremacists with an incredible opportunity to spew their messages into the public. And the Charlottesville trial lasted 4.5 weeks. There were just innumerable times that the defendants, these white supremacist defendants, made incredibly virulent racist and anti-Semitic comments in the courtroom over and over. And in fact, not only did they make those comments, they played videotapes of themselves committing violence as a way of normalizing that violence. So it really provided them quite a platform to bring their messages into, a very mainstream place, a federal courthouse. There was an audio feed out of the federal courthouse that anyone could dial into. At one point, the white supremacist, not presumably the defendants, others got a hold of that audio feed and started spewing racist attacks through the audio feed from the courthouse. So it just provided them a platform that they wouldn't have otherwise had. I and other white supremacist researchers of white supremacism have worked with media in the past a lot about the risk of amplifying messages by white supremacists when they're covering that. And I think that message has gotten through a lot. So if you didn't see much information about the Charlottesville trial, I think the media was quite remarkably circumspect about not amplifying what was going on in the courthouse. Another drawback is that case could have lost, right? So a loss is very much in public view, and had that case not resulted in a verdict against the white supremacist leaders, they would have seen that as an enormous victory. So it's a potentially high gain strategy, but it's also a potentially high risk strategy. One of the advantages and sort of the issues about serving as an academic expert, again, not a lawyer, in legal cases like the Charlottesville case. So one thing is it gives you the opportunity to have much faster and potentially more profound impact of your work than we normally would have in traditional academic processes, right? So we normally have findings about white supremacism, and we would hope that these would sort of make their way into some kind of impactful process, but this is more directly impactful. It's also a public and important way to indirectly educate, media, law enforcement, and so forth about the white supremacist movement without, using the traditional academic methods of papers and presentation. It's a method for acquiring incredibly valuable sources. So what the attorneys were able to get from the defendants was information that in most cases was really otherwise unattainable, right? We don't normally have access to people's cell phone records. And in a movement that operates behind the scene, that is an unusually valuable kind of information. And finally, it's a really interesting learning process for an academic to be involved in a case, especially to this extent. It's a very focused exercise in how hard it is to be in a position where you have to defend every single word, every interpretation, every inference, every piece of evidence you put forth in a report. So, as academics, we're used to scrutiny, but we're not used to scrutiny in the same way that you are scrutinized when you have, in this case, multiple attorneys on the other side scrutinizing every word. It was a good lesson in how a few easy to explain concepts, culture, back and front stage, doublespeak, turned out to be much more useful and persuasive to the jury than the kind of complicated argument that we are often prone to make in academic circles. So it was really a useful exercise in thinking about how to really hone down complicated academic work into a more succinct form. And also it was a good lesson in learning how to explain how we work in a non-technical fashion. So I'm a sociologist, and we are expert at having very complicated explanations of our methods and styles of research, but that doesn't mean anything to a jury. And so it was very useful in trying to think about how to hone down an explanation of what we do. Because as an expert, what you want to be able to convey is that you're really making an analysis. You're not just a hired gun who's been told what to say in the case. And lastly, there's drawbacks to being an expert. And I would say almost none of these I realized before I got involved in this. Which is my own naivete on this for a case this complicated. So one is that the pace and logic of legal cases was just profoundly different from the pace and logic of academic research. So in academic research, you're used to, making the pace of your study. You weigh evidence, you double check and triple check interpretations. In a case like this, the argument at stake could change very quickly and requiring different evidence with very little time to keep double and triple checking everything. There's also a really profound issue of compatibility or non-compatibility between social science evidence, which is probabilistic, right? In most cases this happens, and legal evidence where the jury's looking for certainty. So, we were asked over and over, does every statement encouraging violence lead to a violent act? Well, certainly not. And from a sociology point of view, that's irrelevant, but it's very relevant in the case. And it's interesting that in a legal case, you can't do what we like to do as scholars, which is qualify everything and attend to every nuance and put everything in context. So, for example, if the question is the Nationalist Front a Nazi group? The answer's got to be yes or no. It can't be what I would say in a class. Well, in this way, yes, and this way, not. So again, interesting statement, interesting direction. There are other kinds of drawbacks. One is that you really have to think through this issue of objectivity. In other words, if you get involved in a case like this, you have to remain open to the possibility that the attorney's theory of the case might be flawed or inaccurate. So, in other words, you can't really get into the situation thinking, I want to get into this because I want to be part of, dismantling white supremacist extremism. That's not the role of an academic expert. The role of the academic expert is to weigh the evidence and give an accurate summation of the evidence. So that's a potential really difficult outcome. Had the evidence not weighed as it did, we could have been in a position of not being able to support the argument of the plaintiffs in this case. And so, again, I don't think I fully understood that, or I understood that, but didn't fully think through the consequences of that before we started. And finally, we were reviewed and were given to review a vast amount of data, far more than in volume than I've ever seen in 40 years of working on white supremacism. On the other hand, data that's generated in the court case stays in the court case. So for the most part, that is not data that I can use or that Pete and I can use in subsequent scholarship. So in one sense, you have opportunity to have information that you couldn't get otherwise, but it can be your ability to use that information can be very limited. And finally, and maybe this goes without saying, in cases that involve white supremacy and white supremacists, the safety and security issues are even more profound, I would say, than they are for researchers in general. So I will stop there and turn over to my colleague, Chip.
Thanks, Kathy, and thanks to everyone for being here. I'm going to be relatively brief. I actually have a few questions for Kathy as well, but I was asked just to add a little bit of legal perspective, and I'll do that as quickly as I can, and then I think we'll be moving to some open discussion. So I want to just tell you, I'm going to talk about two things. One is just to give some brief background about one of the statutes that was at issue in the Charlottesville case, and indeed is also being used in a lawsuit arising out of the January 6th riot at the Capitol, an early civil rights law called the Ku Klux Klan Act. I want to talk a little bit about what that is and how it came to be. And then I'll just take another couple of minutes to rip off of something that Kathy mentioned about the possible benefits and downsides of litigation as a strategy for social change. So as to the first, if I can make the screen share work, I just had two slides that I wanted to show by way of background. So to introduce these, I will simply mention that the federal civil rights statutes that were adopted in the wake of the Civil War represented a very profound change in the view that the legal system would take toward issues of racial subordination and violence. Prior thereto, most racialized violence, certainly at the federal level, was not addressable by the legal system or was not addressed by the legal system. And even at the state level, there tended to be very few tools that governments could use in cases involving private discrimination or violence on the basis of race or identity. So what I want to do is to give you the world's briefest tour through the period of time called Reconstruction, the period of time after the Civil War that gave rise to several new constitutional amendments and statutes that were adopted pursuant to those amendments. So I hope that you all can see these slides. I actually cannot see you, so I can't tell, but someone shout at me if you cannot see what the heck I'm talking about. So as you know, after a cataclysmic civil war fought on American soil, the Constitution was amended to add 3 new constitutional amendments dealing with the status of the newly freed persons in our reconstructed society. The first of which was the 13th Amendment. The 13th Amendment is most familiar as being the amendment that constitutionalized the abolition of slavery. So the text of the amendment provides that neither slavery nor involuntary servitude, except as punishment for a crime, shall exist in the United States. And then it contains what's called an enforcement clause, whereby Congress was given the ability to enforce this provision by appropriate legislation. The plain text of the 13th Amendment, in the view of many scholars and indeed some courts, doesn't reveal its full scope, because the framing debates that led to the adoption of the 13th Amendment indicated that in addition to intending to constitutionalize the end of chattel slavery, the 13th Amendment was also intended to abolish what its framers called the badges and incidents of slavery. Please don't try to follow this entire wall of text. It was designed for a different purpose. But the highlighted portions there are put in bold to indicate just how broadly the 13th Amendment's framers thought the new Constitution would reach regarding the legacies of slavery. And so they certainly spoke of abolishing the chattel property relationship of American slavery, but also spoke much more broadly about what some of the incidents and legacies of slavery were, and that the new Constitution, the reconstructed Constitution, would permit Congress to address those as well. Here you see a couple of those framers articulating a few of the things that they believed were badges or incidents of slavery. What is not up here is something that very much runs through the framing debates, which is the use of private violence with impunity as a means of social control over enslaved persons, and indeed, even after the Civil War, as I'll discuss in a moment, over free Blacks as well. The 13th Amendment was quickly followed by the first significant federal civil rights statute, the Civil Rights Act of 1866, which attempted to articulate some, but not all, of the badges and incidents of slavery that those framers thought would be abolished by the 13th Amendment when it abolished slavery. And thereafter, there is a burst of federal activity that I think is still unmatched in American history to try to remediate the status of formerly enslaved persons. So shortly after the Civil Rights Act of 1866, the 14th Amendment is adopted, yet another amendment to the Constitution, which the framers thought necessary because the recalcitrant former Confederate states were not respecting either the 13th Amendment or the Civil Rights Act of 1866. And the 14th Amendment is the post-Civil War provision with which most people are familiar when it speaks of the guarantees of equal protection, due process of law, and citizenship. The 14th Amendment then was followed quite quickly by what's pertinent here and was used in the Charlottesville civil case, as well as one of the cases arising out of the January 6th riot at the Capitol, the Klan Act of 1870. The former slaveholding states, and indeed former slaveholders themselves, because slavery in law had been abolished, attempted to use a variety of means to reestablish slavery in fact among their Black populations. One of them was terror. That is to say, often masked, often at night, often in large mobs, the use of private violence as a means to reestablish a system of control over newly freed slaves in the former Confederate states. And so Congress began to see that merely having the 13th Amendment, the first Civil Rights Act, and the 14th Amendment on the books, if you were, would not be sufficient to withstand that sort of move toward retrenchment and reestablishment of white supremacy in the South. So they adopted the Klan Act specifically to deal with one of the badges and incidents of slavery, which was that in most of the South and in a goodly portion of the North, one did not need the formal legal mechanisms of oppression and subordination in order to accomplish those goals, because they could be accomplished just as well, and indeed perhaps more quickly and efficiently, through the use of violence, fear, and intimidation. So the first Klan Act, as well as the second Klan Act, which is the one that was actually used in the Charlottesville case, provided for, among other things, making it a unlawful conspiracy to conspire to deprive persons of civil rights through the use of force or violence or the threat thereof. In between the two Klan Acts, the 15th Amendment was adopted and amended in the Constitution, which provided that the right to vote shall not be abridged on account of race or color. Congress in 1871 adopted a second Klan Act in order to add additional grounds on which one could bring a federal civil action against other private persons who deprived you of your civil rights. And the Civil Rights Act of 1875 was Congress's first attempt at prohibiting segregation in places of public accommodation. I mention all of this simply to contextualize those Klan Acts in the context in which they were adopted, which was a context in which the newly reconstructed country was to embark upon an aggressive enterprise of driving out root and branch the legacies of slavery and the prior system of subordination. So those Klan Acts were not adopted in a vacuum. They were adopted against a background whereby the use of private violence to subordinate and oppress was a key aspect of the slave system that had to be attacked and addressed if we were to move to a state of freedom for all. The Klan Acts still exist in modern form today. They are codified in various provisions of federal law under Chapter 42 of the United States Code. The ones that are most pertinent in the Charlottesville case and the January 6th case make it illegal, that is, provide a civil cause of action for a plaintiff who alleges that two or more private actors have conspired to deprive a person of their civil rights by force, intimidation, or threat. And they allow the plaintiff, if successful, to recover monetary damages as well as to get court orders that the defendants cease engaging in such conduct. A lesser known provision, which I'm not sure if it was used in the Charlottesville case, also provides a federal civil cause of action, not only against individuals who actively participate in a deprivation of civil rights, but also against individuals who possess knowledge of such a conspiracy and fail to prevent the conspiracy from occurring. And so this is one of the things that perhaps we'll discuss along with Kathy in terms of the operation of modern white supremacist groups. There may be a broader pool of potential defendants by virtue of that failure to act provision. The last thing I'll note briefly, and then I do hope we'll have time for some discussion, is just a riff off of what Kathy said about litigation. So litigation is weird, especially if you're not a lawyer, but even if you are a lawyer, it is just a very kind of formalized, ritualized way of gathering and communicating information and apportioning blame and responsibility. It follows a variety of very formal internal structures that aren't necessarily mirrored in anything else that we do. And so that means a few things when you're thinking about litigation as a tool for social change. Excuse me. One is that you don't necessarily have to win every case in order for such litigation to be valuable. I think Kathy's right. Losing the Charlottesville case would have been a significant blow in that context. But there's a school of thought followed by civil rights litigators and scholars for many decades now that sometimes litigation has a value that is expressive and communicative. That is, it brings to the public eye either certain actors or certain situations that have not garnered public attention, and that may indeed do so by virtue of being in the formal legal system. So my colleague Jules Lobel writes about this as winning by losing. One civil rights strategy, even if you anticipate that you may lose the case today, is to build public support for the cause to hopefully allow the case to be won tomorrow. Civil litigation also serves, although and primarily serves instrumental purposes. In the context of a civil action, the main things it can do is to deprive the defendants, here white supremacists, of the tools, that is money, that are necessary to engage in the harm that they wish to engage in. And as Kathy noted, it can also expose some of their tactics and machinations to public view through the use of discovery tools and testimony in court that otherwise simply would not be known to the public in general. I am just going to make one last point, and then hopefully we can open it for discussion. As I was describing the evolution of the Reconstruction period constitutional amendments, I noted that there was a point in time where those framers and Congress people decided that simply having the laws on the books would be insufficient. They would have to be coupled with some sort of very concrete tools to bring about equality. One set of those tools were private civil actions that individuals could bring if they were harmed or threatened with harm by persons who wish to deprive them of their civil rights. But I would just note in closing that ultimately even that was not enough alone. The Reconstruction Congresses understood that unless those judicial remedies were coupled with strong, centralized, in this case, federal aggressive action, that is the threat of an overwhelming amount of force being brought to bear, that eventually even those laws that could be operationalized might be insufficient to achieve full justice. And so I just add a note of caution that the formal legal courtroom system in and of itself has never, as far as I'm aware in this country, been sufficient to effectuate significant social change. It was not true with the abolition of slavery or Reconstruction. It was not true of the civil rights movement of the 50s and 60s, where significant executive power was brought to bear to solidify and protect whatever gains were garnered through the legal system. So I will stop there. Thank you for your time and attention, and I look forward to some discussion.
Thank you, Chip and Kathy. That was great. Let me start with a question from the chat. So Michael Yoder, who is one of our new Collaboratory postdocs, asked a question to Kathy about how you go about analyzing such a huge volume of communication from Discord, social media, cell phone records, etc.
Yeah, thank you. That's a great question. In this case, we felt like we had to analyze it in a different way than we would had we've been writing for an academic paper. So if we had this corpus of material for an academic paper, we would have sampled, we would have clustered and drawn, different subsamples. We would have done all kinds of things to make this an expeditious process. So one thing that was different between writing an academic paper and testifying in Charlottesville is we had to be able to respond to cross-examination on any one of those posts. So we had to literally read every post personally. So, I mean, I would say that is a tremendous difference. I probably should have commented on in this case, because these were posts from all these various to and from these various defendants. So we needed to be able, they could have put up any of them on the screen in the trial and say, how do you interpret this? How does this fit with the conclusions you made? So it was, back to a much earlier style of scholarship of literally hand analyzing everything.
And did you do it all yourself, or were there a team of people? Did you have assistants? How did that work?
We had one assistant, but again, because the assistant was not, writing the report, Pete or I had to have our eyes on everything personally. So the assistant could kind of help do the meta-analysis, but that really is one of the difference between the sociologists, where you're trying to see the trends and the overall pattern, and this legal case where they were making each defendant's actions were at stake here, and the actions were represented in the data that we had to analyze.
Thank you. Okay, question from the chat from Joe Yun. How did you actually get the data? Did the platforms give them to you due to the case? And if so, how was anyone sure that the platforms were providing all of the data that needed to be considered? So
now here I'm going to be a little fuzzy because this was done by the attorneys before we came on. So the attorneys secured the data from the Discord platform that was provided to them from Discord. How do we know it was accurate? We know it was accurate in part because it almost at the same time, Unicorn Riot, which is a hacking group, did a data breach of the Discord data that was used to organize Charlottesville. That was a subset, a small subset of what we had access to, but we actually went back and forth just to check to make sure that the same data was being represented. So, yeah. And so they provided data in all the channels that were used to organize the Charlottesville Unite the Right event, not the entire Discord platform. Discord's organizing servers and channels. So they were able to ask for just the part that was used for the Charlottesville organization.
And I would just add briefly that there are court enforceable tools that the attorneys would have used to gather this information. So if it's information from one of the other parties in the case, there's a process called discovery, deposition, document production, whether electronic records or otherwise. And then for non-parties like the companies at issue here, you can ask for a subpoena to be issued that specifies the terms of the information that the company must produce.
Actually, let me just jump on that for a minute. I talked about how trials are disruptive to the white supremacist movement. Even the process of discovery was highly disruptive because a number of them wouldn't turn over things. They destroyed. They did all kinds of they didn't follow the subpoena requests in all kinds of ways. So a number of the defendants were had fines. Some of them ended up in jail. They also, one defendant made threats against one of the lawyers and ended up being sanctioned for that. So even the process of the case before we got anywhere close to the trial was highly disruptive. And in the process of this, defendants started to turn against each other. So the infighting, which is rife anyway among white supremacists, became really exacerbated by the discovery process.
Yeah, and sorry, that's another thing that litigation can do. It's not necessarily the case in every single case, but one of the things it can do in a case like this is the following. For people planning violence or illegal activity of any kind, all of the costs of their behavior are generally externalized, right? And so it's the victims, the targets, society that bear the cost of what they're doing. One thing that litigation can do, it has to be a meritorious cause of action, but if you have a meritorious cause of action, one thing it can do is what Kathy just said, which is to internalize some of those costs and to make them bear some significant costs for their behavior, whether it's monetary or whether it's the transaction costs of having to dig through 27 years of records, whatever it is. It does kind of change the balance a bit.
Thanks. I don't see any more questions in the chat. Chip, you had mentioned that you might have a question for Kathy.
Yeah, Kathy, in the Charlottesville case, if I heard you correctly, and it was interesting, your comment about perhaps the media was purposefully circumspect was an interesting one, because as I was thinking of what I read about the case, I didn't see an answer to this question, and it could have been purposeful or not. But from what you said, it seemed like this was largely kind of ringleader level defendants. Is that correct?
Correct. Yes, they were all leaders of the groups.
Okay, so I wonder then, given what I mentioned about one portion of the post-Civil War civil rights statutes, about whether it would be even beneficial to think about civil actions against people who were not ringleaders, but who were aware and failed to intervene. In terms of how white supremacist organizations actually work, is that likely to backfire and just build greater feelings of solidarity, right? Like, I'm not going to snitch on my idol, or because of some of the fractiousness that you mentioned, might it actually serve a purpose?
So because this was mostly organized on Discord, which is an anonymous platform, you don't put your name on when you post, we were able to get the names of the post names, the handles of the defendants, but not of everybody else, right? So one problem is you couldn't really identify who was part of the conspiracy beyond the defendants because they have handle names, right? You could go after the people who were participating in the violence at Charlottesville, and there's some actions against them in particular, including criminal actions. But again, that kind of gets back into the same problem that, organized crime cases have had, where you're going after the people who are committing the violence, but not orchestrating the violence. So, but this is really an issue as white supremacism moves online in terms of its organization, not its violence, but the organization of violence is primarily online as opposed to in groups. So it's increasingly anonymized organizing, and therefore very difficult to go after even in a civil case.
We have a question of how you determine and confirm awareness.
Awareness of, I'm sorry.
I assume awareness of the plans. I don't know if the person who asked
Oh,
it
relevant maybe to the point that I made about this other provision that allows you to bring a civil case against someone who was aware of but failed to prevent such a conspiracy to deprive civil rights. So the short answer is I don't know, because I've never personally litigated one of those cases. The slightly longer answer is that it's not an unknown concept in the law to try to define the requisite state of awareness or advanced knowledge required to impose liability. And so I don't want to go too far down that path, but it can't simply be that you knew that one day something might happen that's bad. You'd have to have some specific level of awareness of the alleged conspiracy to deprive civil rights. So simply reading it on Discord probably is not enough, right? You have to, I think, have a little bit more particularized information to be said to have the requisite awareness.
Be interesting if that gets used at all in the January 6th case, which at least one of the cases, the plaintiff is the District of Columbia because of the damages to the city caused by January 6th. So that will be interesting to follow this up.
Chip, do you have time for one more question?
I do.
Okay. So this is a question about January 6th. Can you comment a bit more on the civil case brought by the DC groups involved in January 6th, the differences, similarities, potential challenges, et cetera?
Yeah, there's more than one. So the one that I'm more familiar with is the one that was brought by in behalf of several Congresspeople who were in the Capitol on the day of the attack. And those are premised under the same statute, the same federal statute used in the Charlottesville case, but a different subsection. So the current statute is currently codified as 42 USC section 1985, and it provides multiple circumstances in which such a conspiracy could provide the basis for a civil action. So one is the Charlottesville iteration, where two or more people conspire and use or threaten violence as a way to deprive other private individuals of their civil rights. The one at issue in the January 6th cases would be a different subsection, which is one that imposes civil liability on individuals for conspiring to prevent an official from carrying out their official duties, which in this case would have been the electoral vote count. Similarities and challenges. I mean, actually, maybe Kathy is better positioned to speak about some of the similarities. It is my intuition that some of the coded elliptical doublespeak used by white supremacist group is quite similar to some of the coded elliptical doublespeak that the former president and his enablers were alleged to have used to incite the Capitol riot. Challenges, though, the main one is this idea of incitement, at least as to some of the defendants, i.e. the former president. The Supreme Court's case law regarding incitement imposes a very, very high legal standard for speech alleged to amount to incitement to not be protected by the First Amendment. In other words, you can walk pretty far in terms of what you are saying before you cross the line from protected speech to incitement. So the primary defense, as I understand it, of the defendants in this particular suit growing out of January 6th is that they did not ask the rioters to riot and breach the Capitol. They did not utter those words. And under the Supreme Court's current precedent, they have an argument. I think that will be the biggest challenge, is whether in fact it's protected speech or unprotected incitement.
Great, thank you. So I think we're about out of time here. So I'd like to thank our speakers. This was tremendous. Thank those of you who contributed some questions, and invite you to join us again for our next seminar, which will be on March 1st. So thank you, everybody.